This channel does not promote any violence, harmful or illegal activities. All content provided by this channel is meant for educational purpose only.
Perusal of the records of a subordinate court or on reading of a report in a newspaper or hearing a public speech without there being any reference from the subordinate court or the advocate general, it can be said to have taken cognizance on its own motion. But if the High Court is directly moved by a petition by a private person feeling aggrieved, not being the Advocate General, can the High Court refuse to entertain the same on the ground that it has been made without the consent in writing of the Advocate General? It appears to us that the High Court has, in such a situation, a discretion to refuse to entertain the petition or to take cognizance on its own motion on the basis of information supplied to it in that petition. If the petitioner is a responsible member of the legal profession, it may act suo motu. More so if the petitioner advocate, as in the instant case, prays that the court should act suo motu. The whole object of the prescribing the procedural modes of taking cognizance in section 15 is to safeguard the valuable time of the High Court or Supreme Court for being wasted by frivolous complaint of the contempt of court. If the High Court is prima facie satisfied that the information received by it regarding the commission of contempt of a subordinate court is not frivolous, and the contempt alleged in is not merely technical or trivial, it may in its discretion act suo motu and commence the proceedings against the contemptor. However, this mode of taking suo motu cognizance of contempt of a subordinate court should be resorted to sparingly where the contempt concerned is of a grave and serious nature.
But here this case is a very serious one and of a very grave nature, and your lordships, after going to the petition, were pleased to observe that this is a very serious matter. Therefore, we give them an opportunity first to deal with it, and thereafter, if we feel that no proper explanation has been given of their conduct, then we'll issue a rule. And that is what your lordships did. Now, the persons have apologized and one said, well, I was not here. I was told specifically by my Lord Justice Bhattacharya that Kunal Ghosh aspect. I shall come to that absolutely in a different manner. But so far as all others are concerned, the issue that High Court cannot take suo motu cognizance in absence of complaint with the permission of the Advocate General is not a proper reading of it.
Now, in reference to this judgment, if Lordship kindly takes up the order by which it was assigned to this bench, it records both the affidavits are related the acts of obstruction of justice, intimation of the advocates, scandalization of the court, and the interference with the administration of justice committed on so-and-so date at so-and-so place. Hence, praying for taking up the matter as suo motu proceedings for criminal contempt under the Contempt of Court Act 1971. Both the affidavits are filed by so-and-so. The matters are most humbly placed with Honorable Lordship for appropriate order. Then order. The matter was mentioned before the courtroom number so-and-so by several learned advocates who were in uniform in their submission that the incident which occurred on so-and-so date at so-and-so place is a clear interference with the administration of justice and a threat meted out to the judiciary and the learned members of the bar. Video clippings was shown to us in which it was seen that one of the person was stamping on the photographs of the Honorable Judge with his feet. The interview given to the concerned YouTube channel was translated and explained to the undersigned in English, from which it appeared prima facie clear that the person was mentioning about the names of Honorable Judge present and past. There was also mention about the orders passed by the Honorable Supreme Court, and the names of the senior advocates were also taken. Thus, I am convinced that the matter requires immediate attention to protect the image of the judiciary from the scurrilous and the baseless allegations Hence, I deem it appropriate to constitute the following special bench. Now, this was the observation of the Chief Justice. Now, in this context, may I read the subsequent paragraphs also, which is also relevant. Court has distinguished contempt in a suo motu proceedings and contempt by a petition filed by the private person. Paragraph 23 and 24. It is settled law that the High Courts, even while exercising their power under Article 215 of the Constitution to punish the contempt, the procedure prescribed by law is required to be followed. High Court in the present case relied on a decision of the court so wherein this court overruled the objection raised on behalf of the alleged contemner that the contempt petition filed by the Supreme Court without the consent of the adversary was not maintainable. The decision was rendered prior to the act coming into force. There was no provision of law at the relevant time which prevented the court from entertaining the petition filed by the interested person, even without prior consent in writing of the Attorney General, of the Advocate General, or the Advocate General, as the case may be. The High Court in the present case rested in its conclusion, relying on the amendments made in the petition, stating that even a suo motu contempt proceedings may be initiated at the instance of the petitioners on going through a newspaper. Be it noted that there is no prayer in the contempt petition filed by the respondent to initiate suo motu proceedings. We are unable to sustain the findings of the High Court in this regard, but the same is not supported by any material available on record. The order dated so and the rule issued is in clear and categorical terms reflects the law was set in motion exclusively based on the amendments made in the petition and the affidavit of verification filed in
kindly pause here for a moment. In our case, your lordship will find that there was no petition. There was merely affidavits for the purpose of bringing it to the notice of the court. Now, mere filing of affidavit does not amount to a petition. And the court, your lordship will see in the decisions to be cited that the court can take a notice of statements made on oath by responsible persons like lawyers and act on it suo motu. Therefore, in our case, this factor is absent. And your lordships may kindly remember that on the very first day, I told your lordship that I am not appearing for any party, but I am for the informer and for some of the persons who have informed the court that this has happened. Now, my lord, in the order sheet, I find my learned friend, Mr. Ahmed, has made it available for me. It raised appearing for the parties, appearing for petitioner, appearing for petitioner. We never appeared for the petitioner. We appeared for the informer in this case. One might say complainant, I understand, but not petitioner. To be a petitioner, there has to be a petition. And the texture and language of the affidavit will clearly demonstrate that we were not petitioners. Therefore, in this case, we stand on a firmer footing. In fact, I would have gone to a stage further to say that since these appearances are marked by the court officers, so they have marked it for the petitioners. It's not a direction of the court. Therefore, Lord, all that has been made is a complaint to show before the court that look here, this has happened. One man go to that extent that I am submitting that this is a fit case for taking up the case suo motu. That does not make it an application. And in Viman Bosch's case, the Supreme Court said, look here, it said it does not even make a prayer for issuing a rule suo motu. So if that is not there, that was based on a petition. If it is based on a petition, then my lord, section 15 is attracted.
So, Mr. Sengupta,
Yes, my lord.
the way you are putting it, can you say this, that the Honorable Chief Justice, the affidavits were filed, those were captioned also as complaints, and their
Yes,
suo motu rule was prayed for before the court's jurisdiction was sought to be invoked, that you issue a suo motu rule. We are not the petitioners.
yes,
Those materials were before the court, and
yes,
as is apparent from the Chief Justice's initial order assigning before us, that video clippings were produced, those
yes,
affidavits were there. On these materials, Chief was of the opinion, Honorable Chief was of the opinion that this matter is serious, should a bench should be constituted and place the materials before us.
yes,
And then we also gathered further materials by seeking affidavits from the alleged containers. And after getting those materials on the first day, we did not issue a rule, as you said. And then it is this court which issued the rule for the first time
yes,
after getting those materials, including the video clippings.
yes,
So this can be governed by, arguably, by Rule 17, which does not confine it to the Chief Justice. It says rules
yes,
issued by any court on its own motion shall be dealt with by that particular court. So the
Hmm.
chief, what the chief judge does is only constitutes our bench, assigns these materials to us, and leaves it on us to take a call as to whether we shall issue a rule of contempt. This is
Your
the
lordship,
Yes.
yes, your lordship has put it more precisely than I could. I was just drawing your lordship's attention to the expression, notwithstanding anything. It does not mean
It's
that-
over and above. It's super additional. In
that's
addition,
right.
that's
That's
very
right.
clear. That's very clear.
Therefore, it's one thing. Say this, and it's another thing. Rules issued by any court shall be dealt with by particular court, provided such rules under section 15 shall be heard and determined by such bench of judges as court chief justice may appoint. Mr. Bandyopadhyay harped on repeatedly rules. Unless you issue a rule, it cannot be assigned. Which means the general power of assignment of the Chief Justice is sought to be curtailed by such interpretation. Because such an interpretation will go against all canons of procedural justice, because the Honorable Chief Justice's power, general power of dealing with matters is sought to be curtailed by such interpretation. Lord, I shall show the decision later on. Supreme Court has clearly said rules of, this is in R.N. Jadi versus Sambut, 2007, 6 SCC 420. Now, don't go by the number of the page.
And
Yes.
particularly since this is criminal
Yes.
contempt. So
Yes. So,
you see, it has changed now. Now under the new provisions, it has changed. So,
it has
so no
changed,
difficulty.
yes. But not, we always, even now we say, he is a 420. The Lord, 420 has got its own place in common vocabulary. Now, Lord, they are supposed to say the rules of procedure. In umpteen number of cases, I shall not trouble your lordship with those cases. I believe there is no dispute.
Sir, Prashant Bhushan's case.
আসছি আগে ওটা শেষ করো দিও ওষুধটা শেষ করো তারপর
Yes, Mr. Rudu.
Number rules of procedure are intended to be a handmaid in the administration of justice and not mistress of it. Therefore, rules of procedure cannot be urged to defeat the substantive purpose of law. And if such a meaning is put, and the miscreants, if I may use the expression, are let off on such technical objections, then it will not only set a bad precedent, but will encourage people at large to take such plea.
We have to paraphrase the language because these words cannot be used now in view of the handbook issued by the Supreme Court. Mistress and all, we cannot use those things. So we'll,
My lord,
paraphrase.
Lord, certainly, but I said if I may be
So
permitted to
it's
say
the language
so.
of the judgment you are citing, so you cannot help.
Yes.
So we'll paraphrase.
That's right.
Not the least, say the best. Now, Lord, this being conclusion, we are placing Biman Bosch's case. Mr. Ahmed will read on the subsequent paragraphs which are relevant. I wish, Lord, I could be personally there to assist your lordships. But
Now, paragraph 24, of Biman Bosch's case, is distinguishes in the particularly in the middle,
Exclusively. Exclusively.
yes,
It is exclusively on the affidavit. If it's exclusively on the affidavit, then
no.
That is the distinction.
Now,
And 25 dilutes it further.
on the next judgment, shall I refer the next judgment?
yes.
This is of 2021, 1 SCC, page 745.
Was this also cited by them? No.
No.
2021.
1 SCC, page 745.
This is Prashant Bhushan's case, where Lord the Supreme Court had taken a serious view of observations made by the London advocate.
And I'm reading only paragraph 18,
রুলগুলো ভীষণ বাজে দীপঙ্কর তুমি এখানেও পড়ো না ওখানে ওই কোডে পড়ো
only paragraph 18. From the perusal of various judgments of this court, including those of constitutional benches, it could be seen that the sources of powers of this court for proceedings of an action of contempt is under Article 129. It has further been held that power of this court to initiate contempt proceedings is not in any manner limited by the provisions of the Contempt of Court Act 1971.
This is what I was submitting before you.
It has been held that the court is vested with the constitutional powers to deal with the contempt, and section 15 is not the source of power to issue notice for contempt. It only provides the procedure in which such contempt is to be initiated. It has been held that insofar as suo motu petitions are concerned, the court can very well initiate proceedings suo motu on the basis of information received by it. The only requirement is that the procedure as prescribed in the judgment of PN Duda has to be followed. In the present case, the same has undoubtedly been followed. It is also equally settled that as far as suo motu petitions are concerned, there is no requirement for taking consent of anybody, including the learned Attorney General, because the court is exercising its inherent power to issue notice for contempt. It is equally well settled that once the court takes cognizance, the matter is purely between the court and the contemner. The only requirement is that the procedure followed is required to be just and fair and in accordance with the principle of natural justice. In the present case, the notice issued to the alleged contemner clearly mentions the tweets on the basis of which court is proceeding suo motu. the alleged contemner one has also clearly understood the basis on which the court is proceeding against him, as is evident from the elaborate affidavit in reply filed by him.
So for us, it is Article 215.
Article 215.
We'll read 120 for 129, 215.
215.
Yes.
And the natural justice is the only.
Lord, two things from this judgment, this paragraph.
And notice this is a 3 judge bench. The
Yes.
other one was a 2 judge bench. Yes.
Number, I made my submission that the source of power to punish for contempt comes from Article 215, not Section 15 of the Contempt of Courts Act. Therefore, such constitutional power cannot be taken away or abridged in any manner by any legislation or enactment of any legislature. And this is more so in respect of rules. This is a case in support of the submission that I have made. And my Lord, another thing, Lord, as I said, Lord, is supported by this judgment. That means it's a purpose. The purpose of it. Once the court takes out cognizance by suo motu rule, the matter goes out of the hands of everybody except in the court. Matters between the court and the contender. These procedural objections cannot be allowed to frustrate the requirement of justice. But the next case, or this case, any further paragraph I marked, I don't remember.
I don't think any
Further paragraph.
না না ফার্দার প্যারাগ্রাফ বললেন
না বললাম যদি কিছু মার্ক করে থাকি
না স্যার আর
No, he has not marked anything else. This is sufficient.
Fine.
Move on to the next.